My name is Ray Brescia. I teach at Albany Law School, which means two things. One, I'm a lawyer, and two, I make more lawyers. Now, you might say, with all that's going wrong in the world, all that's going on in the world, do we really need more lawyers? Well, I'm going to make the case. I'm going to establish four sort of counterintuitive ideas in this talk and try to make the case that we do, in fact, need more lawyers. So one, first counterintuitive idea, we need more lawyers. Two, not just any lawyers, we need creative lawyers. Three, creative lawyers are often integral players in efforts to bring about social change. And the fourth point, perhaps the most counterintuitive of all, is if you want social change, go to law school. Whoa, right? We don't often put those ideas together in the same sentence. Creativity, lawyers, social change, right? Often, lawyers are the butt of jokes. In fact, there's a whole class of jokes, right? Called lawyer jokes. So lawyers often seen as conservative, as staid, as preserving the status quo, right? We can look at sort of one of the more famous lawyer jokes, perhaps, from the Bard, right? First thing we do, let's kill all the lawyers, right? Was Shakespeare making a lawyer joke? What do you call 1,000 lawyers at the bottom of the ocean? A good start, right? Is that what Shakespeare was saying? Well, actually, if you go to the play, right, where this appears, this famous line appears, it's uttered by Dick the Butcher, appropriately named Dick the Butcher. Dick doesn't cut meat, just telling you, right? Now, he's talking to his buddy, Jack Cade, right? Jack Cade, rebel usurper, wants to be king, okay? The lines that precede this line are the following. It's Jack Cade describing his reign, okay? There will be no money. All will eat and drink on my score, and I will apparel them all in one livery, that they might agree like brothers, and worship me, their Lord. Huh. Let's see. No money. Okay? Everyone agrees, sort of groupthink, right? Everyone's dressed the same. Sounds a little bit like, you know, Maoist China or maybe North Korea today. So when Dick the Butcher says, first thing we do, let's kill all the lawyers, it's saying, Jack, in order to create your reign, we need to take the lawyers out of the picture, right? The lawyers, for Shakespeare, would stand as a bulwark against authoritarianism, okay? So for Shakespeare, the lawyers, right, can fight despotism. Now, I'm going to go one step farther than Shakespeare and say the lawyers actually can promote positive social change. I'm going to use three examples to do so. First example is actually two lawyers, right? One of whom you've heard of before, one you probably have never heard of before, okay? That second one was a Union general in the Civil War, abolitionist, lawyer in peacetime, probably one of the most unlikeliest of social change advocates. This guy, Benjamin Butler. Benjamin Butler was a Union general, and he commanded a fortress in northern Virginia at the start of the war. And one night, 3 slaves escaped from their labor on the Confederate side, got to the Union side, they crossed no man's land, and they presented themselves to Butler and said, we'd like to be free. Butler said, wait a minute. Fugitive Slave Act, which was the sort of one of the main flashpoints in the, what brought us to the Civil War, required that Butler return the slaves. Butler looked at the law, as any self-respecting lawyer would do, and he said, wait a minute. Fugitive Slave Act says So if a slave escapes from a slaveholding state to a freeholding state, we have to return them. In fact, the owner could enlist the federal government to return the slave. Butler said, wait a minute, Virginia, by its own acts, is no longer a part of the Union. It's not really a state anymore. I'm going to read the Fugitive Slave Act to say these slaves aren't covered by it. I'm not going to return these slaves. Moreover, and this was even more controversial, he said, now these slaves were working on the Confederate side as slaves, helping to build a fort, as slaves were being used throughout the South, in munitions factories, driving trains, right? And he said, what if I had come across Confederate cannons or gunpowder or horses, right? I wouldn't return them to Confederacy. That would be lunacy. So these slaves, like the gunpowder or horses or cannon, they're contraband of war. Now, for the abolitionist, this was quite controversial, right? Because he was buying into the South's argument that the slaves were property. They were contraband. Yet it did the trick in terms of the legal argument. In fact, the next night, when a Confederate colonel had the temerity, under a flag of truce, to present himself to the Union lines and said, I'd like my slaves back, Benjamin Butler said, I don't think so. Now, Butler, other Union officers took similar actions, right? They sort of forced Lincoln's hand, the second lawyer I want to talk about, right? Forced Lincoln's hand. He had a very fragile coalition that he was trying to hold together. Unionists who wanted to preserve the Union, abolitionists who wanted to end slavery. He had to find a way to keep them together, right? And he found it in the Emancipation Proclamation, because the Emancipation Proclamation would do two things. It would not just free the slaves, it would also make them available for pay, of course, to work for the Union side. So he'd satisfy the Unionists who wanted to win the war. He would satisfy the abolitionists. So crafty lawyer that he was, he brought these parties, these coalitions together, right, in the Emancipation Proclamation. But he couldn't release it at any point, right? He couldn't just think about releasing the Emancipation Proclamation at any time. If there was a Union loss on the field of battle, releasing the Emancipation Proclamation would make him seem weak. He had to wait for a victory, right? And he got one. Battle of Antietam, fought in Maryland, right? Most historians would say it was a stalemate. Nevertheless, Lee had to retreat. Lincoln had his victory, announced the Emancipation Proclamation. The Civil War became a war about defeating slavery and keeping Lincoln's coalition together. Now, fast forward to the post-World War II era, right? We just won a hot war. Now we're in a cold war with the Soviet Union. And one of the problems that the U.S. faced on the global stage was Jim Crow, right? The lasting vestiges of slavery for all intents and purposes, right? Jim Crow in the South was a problem for U.S. foreign policy, okay? It was also immoral. And advocates, the NAACP, Legal Defense Fund said, not unlike Lincoln, we can bring together different interests to promote an end to Jim Crow, but we need a toehold. We need a legal toehold. We need to put these issues to the test, right? So they started to think about ways to challenge segregation, okay? Now, we all know about Brown v. Board of Education, the most famous Supreme Court case in history with good reason. But that case was preceded by other cases where the NAACP, creative lawyers, took little bite-sized chunks of segregation, right? They sought to challenge institutions one by one, and one of the first institutions they challenged was the University of Texas's law school system, okay? Now, good idea, take on a law school, right? Judges would understand, right, about segregation in a law school, right? They would get it. Now, the law of the land was separate but equal, right? What Texas, the problem Texas had was there was no separate law school for African Americans, right? There was just one law school. It was only for whites, okay? NAACP said, well, we're going to challenge segregation on its face, and we're going to use anthropologists to argue that segregation is stigmatizing, is unfair, it's immoral, but we're also going to take the arguments of the enemy and put them on their side and say, okay, separate but equal, it may be the law, but that means you've got to have separate and equal, and it's really hard to have a separate and equal law school when you have no second law school, right? So regents of the University of Texas hastily put together a law school, said, look, we've got a law school, we've got a couple of offices in a business building, right? We've got 4 or 5 faculty members. We have no students. We're not accredited. We have no books. We have no alumni, right? But we've got a law school, right? Put these facts in front of the judges, and they say, well, that's not an equal law school because a law school is more than the building and the books. It's a network and it's a hub. Right? A law school is about ideas, and it's about mentorship, and it's about connecting people to the legal community. It's not just about whether you have a building. Right? Clever, crafty lawyers of NAACP knew that judges would understand a law school isn't about a building. Right? Now, by the time the case goes to trial, here's the difference in the 2 law schools, right? So university regents, they've worked hard. They've got 16 full-time faculty to 5, 850 students to 23, 65,000 books to 16,500 books, accreditation in the University of Texas Law School for whites, pending for that for African Americans, and still no graduates, no alumni network, right? Led the court in a unanimous decision before Brown v. Board of Education to say, it is difficult to believe that one who had a free choice between these law schools would consider the question closed. Now, this decision issued before Brown v. Board of Education becomes a stepping stone to Brown, right? This time, the advocates challenge segregation on its face. Right? They're no longer saying, separate but equal. You need to have equal institutions. They say separate, is unequal, is unconstitutional. But the ideas were germinated in the earlier case, Sweat v. Painter. Okay? Fast forward another 50 years. The effort to attain same-sex marriage. Right? Same-sex marriage, advocates pushed for it for years, small victories here and there, right? But they faced many challenges as well. They faced a backlash. They faced opponents of same-sex marriage, putting ballot initiatives on states, mostly conservative states, to say that marriage could not be between people of the same sex. Right? And they won. The opponents won in state after state. Opponents got a little aggressive. They said, okay, now let's try California. And the advocates for same-sex marriage said, whoa, we got them here. California, liberal state. 2008, it's going to be a big presidential election. They're going to put this on the ballot. We are going to win, say the advocates. Right? On a night when President Obama won California handily, the Proposition 8, which held that same-sex marriage was illegal in California, won as well. Advocates were dumbstruck. Right? Took a step back. They did a 360-degree review of their efforts. They said, well, what did we do wrong? Right? They brought in outside experts. They brought in researchers. They brought in psychologists, communications experts. They said, what did we do wrong? They took surveys. They talked to voters. And the voters said, you had very legalistic arguments. You talked about people being able to visit their loved ones in the hospital. You talked about disability benefits, right? It seems like you wanted something different. And the advocates said, well, no, that's not right. We wanted the same as others, right? We wanted marriage equality, right? And so they started talking about marriage equality, right? 2012, they win a few states. 2015, they win at the Supreme Court on that equal protection argument. And in fact, love would win. Now, I submit to you that there are 5 I's of creative lawyering that I've tried to identify here. Okay? It's incremental and iterative, right? Slowly building the case. It's interpretive, right? Think about Butler, right? Sort of taking on the arguments of the enemy and turning them on their heads, right? Picasso said, good artists borrow, great artists steal. I would argue that great creative lawyers steal as well, and often steal from their adversaries. It's interdisciplinary. The marriage equality advocates brought in other experts, just as the civil rights lawyers did a few decades before. It's interest-based. It looks to bring together interests and coalitions, right? Just as Lincoln did with the Emancipation Proclamation. It is interconnected, right? It is connected to the outside world. It doesn't exist in a vacuum, right? Lincoln knew that he needed a victory in the battlefield to present the Emancipation Proclamation. So, creative lawyers often play critical roles in social change, right? They're not the drivers of social change, but they're on the bus, right? Good creative lawyers move incrementally. They interpret. They work interdisciplinarily. They're interest-based, and they're connected to the world, right? So, to Dick the Butcher, I disagree. The world needs more lawyers. And if you want social change, go to law school. Thank you.